What's up? It's Friday night. What's up? Y'all tap in. Getting to the advanced aspect of things now, man. Oh, man. Watch out. Yeah, we getting to it, man. We the people shall prosper. What's up? How's it going, Jenny? So I want y'all just to right now what I got going on is some family things are going on actually. What's up, Sovereign Seeker? What's up, Grateful Dad? Yeah, we got our mother-in-law is in the hospital right now. She has some high blood pressure, so if you can in your mind just pray to Candy or pray for Candy and that she gets better and that everything goes okay and to plan, and y'all just in your mind just say get well, Candy. That's all you gotta do. That's all I ask. Okay. Um we in this thing. This is gonna be the advanced part 2 again of that procedure. You dig what page are we on? Oh, we're in chapter 2 though. But again, yeah, I wanted to get straight into it. This is on that educational, deeper aspect. Everybody's been asking, what's the process? What's the procedure? We need to know. Let us know. Okay, calm down. So we're going to get back to it again. This is the Advanced Criminal Procedure and Canonical Workflow. I created this with power inherent in the people and all the people and all the people and all the people. We put this out on January the 7th. Okay. So let's get down to chapter 2. Find out where this bad boy's at real quick. Let me scroll. Sorry, I had to come up and show y'all the beginning. How are y'all doing tonight? How is everybody doing tonight? Aren't y'all just happy to be blessed and happy and here and lovely and free? What's up? Yeah, man. What's good, y'all? I'm so happy. It's a good day, man. It's a good day. I know we have some family things going. Everything's going to be all right. I already know. I already know how it goes. I can't say your name, Pants. What's up, NorCal? What's up, Vicious? What's up, Cops are 5150. What's up, the tribe? What's up, Christian? What's up, Christopher? I see you. Yeah. Yeah. What's up? Hold on. I gotta fix something. Hope y'all are doing well. What's up, Breon Smith? Everybody in this thing tonight. Okay, watch out. I see y'all. All right, let's get to it. So, chapter 2, the pre-charge, the investigatory stage, probable cause and preliminary burdens. Section 2.1 now, articulating that probable cause, because that's a big deal that we've been forgetting, apparently. Constitutional standard for probable cause, the Fourth Amendment context. So the Fourth Amendment now to the U.S. Constitution provides, quote, the right of the people to be secure in their persons, houses, papers, and all of my effects. That's my microphone and everything that I own. Oh, man, come on. Go and touch the keyboard up there, and now we done got lost. Against unreasonable shall not be violated, and no warrants shall issue, but upon the probable cause. So right off the bat, we know, and that's unquote, right off the bat, we know that they just can't be taking our stuff because it's ours. It shall not be violated. You can't just take our stuff without certain things. That means your car on the side of the road after they want to come and stop you. This constitutional mandate requires reasonable belief based on articulable facts that a crime has been committed. And we all know what a crime is, right? What is a crime? What is a crime? What is a crime? That's harm to somebody. You hurting somebody. That or you financially hurting them, you know what I'm saying? And two, the suspect in question is responsible for that crime, or that evidence, contraband, will be found in the place to be searched. 2, foundational case of Brenegar versus United States in 1949. The Supreme Court explained probable cause as facts and circumstances sufficient to, quote, warrant a man of reasonable caution in the belief that an offense has been or is being committed, beating up somebody or something. You see what I'm saying? Offense. Offense is a crime. A crime is harm. Like I'm actively about to hurt someone in some way. Oh well, Cameron hurt me because he was on the roads without insurance. He has private plates on. Man, what? What you tripping on, bro? We can't have that. What? What? Oh my God. Key quote. Quote. Because many situations which confront officers in the course of executing their duties are more or less ambiguous. Rebut the presumption. Room must be allowed for some mistakes on their part, but the mistakes must be those of reasonable men. Unquote. Do we have reasonable men? Do we have reasonable men out there doing what they're doing? If you're doing it for a reason, oh man, I really thought. But if you're out here, I'm gonna go through with it anyways, and I know I'm wrong. What? There's a big difference between that. 3, reasonableness and objective standard. The emphasis is on an objective standard. Objective standard. What a reasonably prudent officer would believe, given the totality of the circumstances, if they are reasonable men. Subjective intentions or hunches alone cannot justify probable cause. Oh, let's listen to that one more time. Subjective intentions or hunches alone cannot justify probable cause. Like Emmy when he walked up to me, or Emmy when he saw those private plates and he called over to Austin and he said, "Hey, get that guy. He doesn't have plates." And then came up to me and was like, "It's obstruction of justice," and put me in the handcuffs. Okay, no, your hunch alone cannot justify probable cause, good sir. Sorry, try again. Number 4, practical illustrations. Example, Officer Jones observes an individual pacing back and forth by a closed electronics store late at night, peering into windows and attempting to open a locked door. Combined with knowledge of recent burglaries in that area, these facts may suffice a probable cause for attempted burglary. Well, number 1, the incident is something that has been occurring. Burglary. I mean, breaking in something all the time. You dig what I'm saying? Harm. Come on, man. Contrast, merely seeing a suspicious individual in a high crime area without more specific factual indications may not meet probable cause threshold. Throwing that contrast in there. So, affidavits and sworn statements. 1, requirement of specific factual assertions. Constitutional primacy demands that law enforcement, when seeking a warrant, must present an affidavit or sworn statement outlining the factual basis for probable cause. In Johnson versus United States in 1948, highlights the necessity that the neutral magistrate, not the officer, be the judge of probable cause. Quote, the point of the Fourth Amendment is that inferences be drawn by a neutral and detached magistrate, not by the officer engaged in the often competitive enterprise of ferreting out crime. Sufficiency and particularity. An affidavit must deal what, when, where, and how, linking the suspect or location to the alleged crime. Boilerplate or conclusory statements, e.g., quote, I believe suspect is dealing drugs, without specifying how or why, typically fail the constitutional standard for probable cause. 3, reliability and credibility. If the affidavit relies on an informant's tip, courts assess the informant's credibility, track record, and a cooperation. For more information on that, y'all can see Illinois versus Gates, and that's in 1983. Under the totality of the circumstances test. Now, get that? Under the totality of the circumstances test, okay? What we getting into now? Test, okay? Overruling the stricter Aguilar Spinelli standard. Even getting deeper with it. Now we invoking something. Even a somewhat questionable tip may suffice a sufficiently cooperated by independent police investigation. Gotta get the details. Illustrative example. A detective's affidavit states, quote, confidential informant CI has provided reliable information in the past, leading to 2 convictions. CI observed the suspect packaging narcotics in the suspect's apartment on June the 10th, unquote. The detective also corroborated via a trash pull. Okay, look at these terminologies. Via a trash pull, showing packaging materials consistent with drug distribution. These facts, if accepted as credible, likely meet the probable cause threshold for a search warrant of the suspect's apartment. See how, but again, all of this stuff has to be met before we get into the aspect of police stops. You see what I'm saying? So, Frank versus Delaware hearings. Overview of the Frank's doctrine. Now, let's look at this old Frank's doctrine and see what we can find. Franks versus Delaware in 1978 grants defendants the right to challenge the veracity of the affidavit used to obtain a search warrant if they make a substantial preliminary showing that the affiant included a false statement, knowingly or with reckless disregard for the truth. Uh-oh, that's pulling right into my boy Luis situation. Uh-oh, let's read that one more time. Franks versus Delaware in 1978 grants defendants the right to challenge the veracity of the affidavit used to obtain a search warrant or claims being brought forth, or the search warrant for his vehicle when it got to the rake yard, which they did, if they make a substantial preliminary showing that the affiant included a false statement knowingly or with reckless disregard for the truth. Quote, where the defendant makes a substantial preliminary showing that a false statement knowingly and intentionally or with reckless disregard for the truth was included, and if the allegedly false statement is necessary to the finding of probable cause, the Fourth Amendment requires that a hearing be held. Rebutting the presumptions, Mr. Tribe says. Perfect. Yo, Mr. Tribe, if I'm saying anything different than what is correct, please rebut the presumptions or assumptions being made by me. I give Tribe all permission to do such. That's for sure. What's up, my boy? So, materiality requirement. Oh, materiality requirement. Jeez, I don't know why. Even if the defendant shows certain statements were false, those statements must be material to the probable cause determination. If probable cause remains after excising the falsehood, a Frank's hearing may be unnecessary or fruitless. You ain't got nothing. Omits exculpatory facts. Frank's also applies where the affiant knowingly or recklessly omits facts that, if included, would deviate probable cause. If the omission is material, a quit may void the warrant. Get it out. We don't want it. Get it out. We don't want it. Okay? Now, the practical impact. Defense counsel often scrutinizes the affidavit's details, search log statements, any disparities, to see if law enforcement overstated or omitted crucial information. If successful, evidence seized under the warrant may be suppressed, significantly weakening the prosecution's case. Interplay with constitutional primacy, due process, and fairness. So, probable cause is an essential safeguard against the arbitrary arrests or searches, tying the criminal process to objective facts rather than suspicion or animus. Okay? If the affidavit lacks specificity or includes deliberate misrepresentations, the entire enforcement action may collapse under due process scrutiny. Let's scrutinize that bad boy. Let's get them. I'm trying to see some due process. Again, these are things we got to invoke. You dig what I'm saying? These are the things that we got to invoke. Fourth Amendment protections. Probable cause is the constitutional floor for invasive searches and custodial arrests. Y'all be talking about, I don't know much about custodial arrest, Cameron. You're going to have to tell me more. Okay. Absent that foundation, the Fourth Amendment's exclusionary rule, get it out of here, exclude it, can bar the use of unlawfully obtained evidence. See Matt versus Ohio in 1961. Public policy. Rigorous adherence to probable cause prevents fishing expedition and helps maintain public confidence in law enforcement integrity. Overly broad or under substantiated warrants erode that trust, or even under-substantiated warrantless arrests. You dig what I'm saying? Warrantless arrests have so many things that they have to fall in line to. You dig what I'm saying? Like, I want to touch base on this for a second. So when it comes down to you getting arrested on the spot, let's say you get pulled over and you doing your right to travel, like I have been for 9 years now, never been arrested. And the aspect that they're trying to, enforce this air of authority and we rule you and we control you, like, bro, that's not gonna fly. And what you have to really realize in all of this is the aspect that if you do not stand on what you know to be true, that you have not harmed nobody and you didn't violate anything, like what? There can be nothing that can be brought against you. And if there is such, you have all remedy. Do I understand? Like, yes, these people are dangerous, yes, but I mean, man, we're a lot more safe now with all these cameras and everything than we've ever been. So as long as we're cool, we should be good in standing. As long as we're asking the right questions in relation to the script. And what I mean by that is if I've gone 9 years to be able to produce myself or conduct myself in a manner that has never been arrested, I mean, that's got to be something. I didn't record all of my interactions, but I've got it all. So what I try to figure out is if we apply ourselves good on the forefront, we have so much action on the back end if we are arrested. Like literally, if you are arrested and have to go through all of that for standing up on your constitutional rights, do you know how much more powerful it is for you that you stood up in the right way? I'll be right back. What's going on? What's up, Steve? What's up, my boy? All right, I had to get some water, dude. I'm getting all parched mouth, not cotton mouth from smoking this weed, dude. I got these things. They're called. Man, I don't even know if I should say it. They're pretty good though. All right. But again, if you stand with humility, if you stand with honor, respect, morality, and you go by the script, we've gone over the transportation script by Eddie Gray. Now we're getting into the details. So public policy, again, the rigorous adherence to the probable cause prevents those fishing expeditions going out, trying to cast and catch one, and helps maintain public confidence in law enforcement integrity. So overly broad or under-substantiated warrants erode that trust. And the warrant lists arrests as well. Scholarly commentary. So Erwin Chemerinsky, criminal procedure, quote, the requirement of probable cause buttressed by a sufficient affidavit embodies the fundamental idea that law enforcement must ground its suspicions in evidence, ensuring the criminal process is tethered to reasoned factual assessment rather than just mere conjecture, unquote. 2. Lawrence H. Tribe, American Constitutional Law. Quote, Franks versus Delaware augments the Fourth Amendment's demand for truth and authenticity in the affiant's presentation. A neutral magistrate's role is rendered meaningless if the court cannot rely on the veracity of the sworn affidavits. Clearly, hello, unquote. 3. Antonin Scalia, commentary on Illinois versus Gates, quote, the totality of the circumstances approach is practical and commonsensical, but it does not relax the fundamental constraint that probable cause be anchored in objective facts, not naked speculation. Ooh. We need them facts, man. Don't be coming over here speculating and then think that's going to hold up with us anymore. It's not going to hold up, bro. We about to eliminate all this. Look at this illustrative. Let's get into the illustrative hypotheticals then. Scenario. A police officer receives a tip that James Smith is manufacturing illegal firearms in his garage. The officer includes an affidavit. Quote, confidential source states Smith is building guns, unquote. However, the officer admits that the source is an ex-roommate of Smith's who was evicted and bears a grudge and fails to provide any cooperation. The magistrate issues a search for probable cause solely on the officer's conclusory statements. During the search, police seize multiple items of evidence. Frank's challenge. Ready for this one? Defense shows in a pretrial motion that the officer recklessly omitted crucial facts about the informant's bias. Get him with the bias, boys! Because these omitted facts, if known, might have undermined probable cause, the court grants a Frank's hearing. If the omission is found material, the warrant could be invalidated and the evidence suppressed. Ooh. Concluding observations. Probable cause stands as the constitutional bedrock of lawful searches, seizures, and arrests, demanding a reasonable belief that an offense occurred and the person or place is associated with it. Affidavits and sworn statements must provide articulable facts, ensuring that a judge, rather than law enforcement alone, validates the existence of probable cause. Franks versus Delaware enforces the integrity of this process by allowing defendants to challenge deliberate falsehoods or material omissions in the warrant affidavit. In all, the constitutional primacy of probable cause fosters both fairness to individuals and the legitimacy for law enforcement, ensuring that the investigatory stage is guided by objectivity and truthfulness rather than mere suspicion. Key takeaway: at pre-charge investigatory phase, articulating probable cause through detailed affidavits is indispensable, y'all. Okay? You see why I'm trying to bring this together, so y'all just get into the procedures of things, getting a little bit more advanced. We're getting into it a little bit more. Some's basic, some's just in depth, some's tying in some things that maybe we didn't know. Courts remain vigilant in safeguarding the Fourth Amendment right against unreasonable intrusions. And if they don't, guess what? We're getting to some disqualifications. Get the judge recused, man. We need what? You not listening to what we got going on here? No, sir. No, man. With Franks versus Delaware as a pivotal check on the veracity of law enforcement claims. And then we got all of our select cited sources and seminal cases. And that brings us into section 2. It's this one. Sorry, baby girl came in here. If I don't, baby girl be on me. Okay. Threshold challenges. So facial insufficiency, definition and core doctrine. Number 1, the deficiency on the face of the affidavit. A warrant application or arrest complaint must articulate specific articulable facts connecting the suspect or place to be searched with the alleged crime. If the affidavit merely offers general suspicions or boilerplate conclusions, it may be facially insufficient under the Fourth Amendment's probable cause requirement. Again, this is all under probable cause, y'all. I hope you're understanding this. All under probable cause. Nathanson versus United States in 1933, the Supreme Court stressed, quote, mere affirmance of belief or suspicion is not enough. Under the Fourth Amendment, an officer cannot make a search under a warrant except upon proof that the place to be searched is the scene of an offense or the place where particular property is concealed, unquote. This case remains a cornerstone in the principle that an affidavit must contain more than a mere assertion of suspicion or an officer's belief. I just can't be out here believing. 3, Johnson versus United States. So in 1948, reinforcing the need for specific facts, the court held, quote, the point of the Fourth Amendment is not that it denies law enforcement the support of the usual inferences, but that it requires that such inferences be drawn by a neutral and detached magistrate. A conclusory affidavit bypasses the magistrate's gatekeeping role, making it ripe for facial insufficiency challenges. Let's do that one more time. A conclusory affidavit bypasses the magistrate's gatekeeping role, making it ripe for facial insufficiency challenges. I like that. Practical illustration. Let's break it down a little bit more. Hypotheticals. The affidavit, quote, Officer Smith observed the defendant standing outside a convenience store late at night, looking nervous. The area has recent burglaries. Officer Smith believes suspect might be planning a burglary, unquote. Facial insufficiency argument. Defense counsel argues the affidavit fails to provide facts tying the suspect to a specific burglary or showing a factual nexus between, you hear that? Factual nexus between the suspect's presence and criminal conduct. Nervous demeanor alone is inadequate, nor property damage, forced entry attempt, or cooperative details. What about that nexus do we know of? Okay? Now, the procedural consequence. If a magistrate or judge agrees the affidavit lacks the sufficient factual basis, the warrant may be denied or voided. Any evidence obtained could be suppressed under the exclusionary rule. Mapp versus Ohio. Exclusionary rule. Suppressed under exclusionary rule. Get that bad boy voided out. Get it denied. What you mean, man? 3. Constitutional and policy underpinnings. The Fourth Amendment, probable cause clause. Sorry, tongue twister there. What? Embodies a protective function against unsubstantiated intrusions on personal privacy. Public trust and judicial oversight. That judicial oversight, y'all don't want to listen? Oh, send it on up. We taking it to the higher ones to come down and look at y'all and make sure that you're doing everything like you're supposed to. Ensuring warrants issue only upon fact-based affidavits preserves public confidence in law enforcement. If you can make that public confidence be questioned or highly questionable, or just in any aspect, honestly get that bias, there's any reasonable bias that you could be showing in relation to what they are doing, got to get the judge about it. If you put it in that box just right, in that line of sight, oh, recusal, a little bit. Because I'm when I come through, I'm leading it all the way back to you don't have a right, period. Can't move forward when you got constitutional violations at play here. And then if you don't go in favor of me and on my behalf, when it says you're supposed to in relation to the rules that I'm invoking, we got to take this up. What you mean? Scholarly commentary. Because look, we're about to talk about it right now. Erwin Chemerinsky again on criminal procedure, quote, the affidavit requirement compels law enforcement to supply a logical factual predicate for intrusions, a factual predicate for intrusions on liberty. You got to really bring something strong to intrude on our liberty. What don't they understand about that? Y'all think y'all just finna come out here and just intrude. What you're going to have to do is come very strong with some kind of factual predicate for intrusions, ensuring that mere conjecture or overzealous suspicion does not morph into sanctioned searches, because we ain't allowing that. Can't allow it. Which brings us on to the next one, which is the rule of lenity. Uh-oh. Okay, cool. The rule of lenity as an early argument. The definition and origin. Ambiguity in penal statutes. The rule of lenity dictates that if a criminal statute remains ambiguous, a criminal statute that describes what the definition is, but is overly broad and ambiguous, after standard interpretive methods, courts must resolve doubts in favor of the defendant. You understand that? In favor of the defendant. Let me check out the chat real quick, man. Because we got the tribe in here talking. I appreciate you. Ozzy, Nathan, I see you in this thing. What's up, Lynn? What's going down, y'all? Y'all in this thing getting it. Tribe. Part logical inferences applying the rule of law in the instance. Part of what people currently are willing to accept as ordinary behavior. Yeah, my boy Kinetic sounds like the fishing story she said, would you believe for show? Tribe says, the conditions in the territory of the venue determine part of reasonableness, common law. Kinetic says, the flip side, the people who don't carry every day think it's ordinary that police are going to be there to protect them. Tribe, all 10 amendments are to be construed as being contiguous. helping Henry that's making 2.5 years in prison. Yeah, if you want to, PP, double P. If you want to, have homeboy, you want to come through on the Discord. The Discord's in the description of the video, bro. You can come on through the Discord. We got a lot of people working back in there. So again, the ambiguity. The rule of lenity dictates if a criminal statute remains ambiguous, it must resolve doubts in favor of the defendant. That's why Luis ain't got no problem with what's coming up. Hey, if y'all can't get them likes up, you dig? Y'all hit them like buttons, man. I appreciate y'all. All right, let's go. United States versus Bass, 1971, quote, where there is ambiguity in a criminal statute, doubts are resolved in favor of the defendant. Now, of course, there's constitutional rationale behind that, right? Clearly, it's rooted in due process and fair notice principles. We've been talking about this, but apparently we need to put it in a layout for everybody, which is fine. Lenity ensures individuals are not penalized under legislation whose scope is unclear. If I can't understand it and you are not very definite in everything that you are stating, how can you then come and tell me that I'm doing something wrong? You got to be very clear. There needs to be a straight delineation of knowing if you even want to try it, which we know you're not because it's so basic that it doesn't need establishing. That's why only arguments you see that's really on the record is the right to drive. You will never see anything being argued about the right to travel. It's just not what's happening. So by restricting prosecutorial expansion of vaguely worded statutes, the rule of lenity vindicates the idea that the legislator must speak clearly if it wishes to define criminal conduct. Invoking lenity at the probable cause stage. Ching chong, let's go get him. Right off the bat, my boy. Right off the bat. Borderline statutory coverage. If the alleged offense arises from a questionably worded statute, e.g., quote, unauthorized access to an electronic device, unquote, without clear definitions, defense counsel could argue there is insufficient clarity to establish probable cause. The conduct actually violated that statute. This argument can be raised early to challenge the complaint or arrest warrant, asserting that because the statute's application to the defendant's conduct is ambiguous, probable cause cannot stand. Cannot stand. Get it out of here. You got weak knees, don't you? Weak knees? There's a whole bunch of statutes out here with weak knees. Illustrative case. United States versus Santos in 2008. The Supreme Court used the rule of lenity to interpret the term proceeds in the federal money laundering statute narrowly as profits rather than gross receipts. Justice Scalia, quote, the tie must go to the defendant because in our system, the tie goes to liberty, unquote. Uh-oh! Uh-oh! Chicka-ching, I need my liberty. Invoking that lenity. Yes, I need my liberty. Invoking that lenity. With that probable cause. Off the bat and early. No, you can't get none of us now. The Constitution violations. Yeah, baby, the foul. I won't allow it. No more. No more. Man, what? Get it out of here, bro. You hear him? What did he say? The tie goes to the defendant because of liberty. I need my liberty. Early relevance. If law enforcement's probable cause rests on an expansive reading of a key statutory. Whoa. Let's go back because I swear to you, the law enforcement does this all the time. And hey, man, that's why we're here. We have to change it. We have to get our education up. We have to start bringing forth suits. We have to start standing for ourselves in these courts when we have claims and charges being brought against us. Let's start it off again. If law enforcement's probable cause rests on an expansive reading or understanding of a key statutory term, defense counsel may brandish lenity to demonstrate that no fair probability of a violation exists under a narrower constitutionally favored interpretation. Oh my God. Oh, that is so good. Why is that good, bro? Because you got to think about it. In this situation right here, bro. In this situation right here, what you got to understand. This is so good. In Luis's situation, when they came up to him and they was like, yeah, dude's about to get you these tickets and y'all be good to go on your way. And then he called up the other guy, and they ain't had nothing to do. So then that guy called up another guy, and he was like, well, it could be forgery. And it says it right, that it directly ties back to what Luis is going through right now. Directly ties back all the way. If law enforcement's probable cause rests on an expansive reading and misinterpretation, clearly they don't know how to read the law, of a key statutory term, such as written instrument, defense counsel may brandish lenity to demonstrate that no fair probability of a violation exists under a narrower, constitutionally favored interpretation. So clear, bro. Like, how could you fail on something so... How? Procedural strategy. Motion to dismiss or quash. Of course, the defense would file a motion arguing that due to vague or overbroad statutory language, no probable cause can be found, and the court may go ahead and dismiss the charge, or at least invalidate the warrant, if it agrees that the alleged conduct falls outside the narrow reading demanded by lenity. That's why we go ahead and have these proposed orders ready to go. The combined impact on probable cause determinations relating to facial insufficiency, plus the rule of lenity. So in some cases, these arguments converge. The affidavit is not only lacking factual detail or facial insufficiency, but also relies on a dubious statutory interpretation. Get that dubious in there. It's almost like when you got people in here filing frivolous filings. Got the prosecutors over here filing NAPSTAD prima facie motions, trying to combat your prosecutorial misconduct that's being called out. Boy, we know you on the fence. We know you on the ropes. Well, you didn't bring up nothing else to argue? Wow. We'll kill that NAPSTAD easy. If the alleged offense is not unequivocally criminal under a strict reading of the statute, the entire probable cause basis may collapse. House of cards. The burden on the prosecution, lay it back on them. Burden on the prosecution. Prosecutors must ensure their affidavits articulate a clear, factual link between the suspect and the offense. They also bear the burden of demonstrating the suspect's conduct unambiguously fits the statute's scope, especially in borderline interpretations. You hear that? If it's borderline, if it's getting close to something that could be considered a tie, we can get it that close, I promise you, in almost anything in life. Because, listen, we don't commit crimes. That's why. You don't commit crimes, you're good to go. You know that, right? If you don't commit crimes, you know you're good to go, right? Okay. Burden on the prosecution. The prosecutors... Oh, we read that one. Preservation for appeal. If a trial court rejects these threshold challenges, listen up. This is a big ding, ding, ding. If a trial court rejects these threshold challenges, defense counsel can preserve them for appellate review. Thank you. Potentially securing reversal if higher courts apply lenity more rigorously, which they will, or find the affidavits insufficiently glaring, which they will. Scholarly perspectives. Lawrence H. Tribe, American Constitutional Law. Quote, the rule of lenity stands as a robust structural check on prosecutorial zeal, ensuring that legislators, not courts or police, define criminality with specificity. Meanwhile, facial insufficiency challenges confirm that judicial oversight, not unilateral suspicion, remains at the core of the Fourth Amendment. Unquote. Erwin Chemerinsky, Constitutional Law, Principles and Policies. Quote, threshold motions often set the tone for a criminal prosecution. Wait. What'd you say? Are you telling me mere threshold motions often set the tone of a criminal prosecution? Did you know that? Did you know if you come in hot and heavy, you might get something moving in your favor all the way around? Threshold motions often set the tone for a criminal prosecution. A well-structured argument of facial insufficiency or lenity can halt a problematic case early on, preventing convictions based on overreaching or vague legal theories, quote unquote. Ooh, I'm gonna get them from the early on. I was talking about wake up, get the early bird. Let's go. Early on, let's go. Number 3, Antonin Scalia and Brian Garner. Reading law, the interpretation of legal texts from 2012. Quote, lenity is but a recognition that criminal statutes, as instruments of state power against individuals, must be read with precision. I'm talking about you better get a scalpel. And if the affidavit for probable cause fails, I'm talking about if it falls or stumbles or trips, like Biden going up the stairs every time on that plane, to show that the defendant's conduct plainly falls, again, like Biden on the plane, or whatever step just on the stage. I mean, it's within that precise ambit, the Constitution compels its rejection. Compels. You hear that? It's, you know what compels means, right? Compels means duty. Compels. It's a duty for them to reject it. So the illustrative hypothetical. I'm going to lay out a scenario real quick. A police officer obtains a warrant by alleging the defendant possessed a disruptive device in violation of State Code Section 215.2, describing only that the defendant's smartphone was modified and used in suspicious messaging. What? Come on, man. Nobody, everybody knows that's not going to fly. But you do got some cops that be trying to pull some stuff like this. We reading one right now. Or we're working on one in the Discord. Defense challenge. Facial insufficiency. The affidavit never explains how the smartphone is a disruptive device. No mention of contraband, hacking evidence, or destructive capacity. Conclusory statements fail to link the suspect's device to actual illegal use. The rule of lenity, State Code Section 215.2, does not define disruptive device clearly. So since it was not defined clearly in the statute, right? So let's just say we get back into the aspect now of thinking of it in regards to the right to travel, right? Let's say the defense counsel asserts a narrower reading excludes intangible software or typical smartphones, so probable cause is defective, right? So if we apply this now to the right to travel, and we're looking at aspects of, hey, you're saying that it's motor vehicles. You're saying, and if we look at motor vehicles, what we find if in its very past, all the way from the very beginning, if we're also invoking the Home Rule Act, is telling us that it was for the purpose of, if we're looking in Bouviers, if we're looking in blacks, we can see that it's in relation to transporting persons or property. Even in a lot of our statutes still today, it states that transporting property or persons. You know what I'm saying? Like it still says that pretty much verbatim all over, except the problem that, you know, we have one problem. Let's check this out real quick. Does this do my whole screen? How does this do it? It's just doing my, if I do entire screen. So if I do this one, okay. So let me pull up something real quick for y'all. Give me 1 second. So drive, and then open as a matter of right. Close that one, and then I bring this over. Okay, cool. So what I want to do is I want to show you this real quick. This is a cool memorandum, right? Just real quick. But when we go into this memorandum, what's pretty amazing is that what you'll see is we could go through several cities. Let me see. Uh-oh, come on now. Public roadway, public highway. Load up now, where the rest of it at? Okay, here we go. Franklin County, public road, open as a matter of public right for vehicle travel. Jefferson County, public road, open as a matter of right of public vehicle travel. Wichita County code, okay, with a port. Highway, Pierce County, highway, Washington, open as a matter of right for public vehicular travel, both inside and outside of the limits. Snohomish, public highway. is generally open as the use of matter for public for purposes of vehicular travel as a matter of right. Yakima County, open as a matter of right for public vehicular travel. Washington cities, this is municipal code now. Estonia, open as a matter of right for public vehicular travel. Bremerton City, municipal code, open as a matter of right for public vehicular travel or parking or similar public use. Open as a matter of right in the I forget how to say that. Do you dig what I'm saying? Do you dig what I'm saying? I could go on and on. Municipal codes. Go look these up. You think I'm BSing you? So we have conflicting things is what's going on. What you got is things that are conflicting. You understand the difference now, what I'm talking about? If you got, who's normally pulling the people over? Who's normally towing the cars? It's the city police, right? Is it not the city police? And if you go and look within your own definitions, within your city and county codes, what you're going to find is that they're sitting here telling you it's open as a matter of right for public vehicular travel. Why not start hitting them where it hurts? All right, let's get it going. Okay. Facial insufficiency, defective outcome. If the court agrees the affidavit is facially insufficient and the statutory term, disruptive device, is ambiguously broad, the warrant may be quashed and evidence suppressed. Concluding observations, significance of early challenges, the facial insufficiency arguments prevent unsubstantiated arrests or searches from proceeding, reinforcing the Fourth Amendment standard. The rule of lenity can nullify ambiguous statutory interpretations from the outset, ensuring that no probable cause stands if the alleged crime is not clearly proscribed by law. Constitutional primacy and procedural integrity. Together, these threshold challenges uphold the due process principle that government must proceed based on clear law and adequate facts. Failure to meet these thresholds can derail a prosecution before trial, safeguarding individual liberty from excessive or vague criminal enforcement. Again, challenging up front rather than going and trying to challenge the statute and what they're saying against you. You see what I'm saying? It's like a he say, she say at that point. I'm not going to play this he say, she say. You think you got power over me and not? It's a constitutional violation in the first place. Leave me alone. Key takeaway. Threshold challenges, whether based on facial insufficiency or the rule of lenity, play a crucial role in protecting suspects at a pre-charge or investigatory stage, ensuring probable cause is anchored in concrete facts and unambiguous statutory grounds. Now we're going to the procedural ramifications, the overview of the judicial determination process, the constitutional basis. The Fourth Amendment mandates that arrests and searches be grounded in probable cause and states that no warrant shall issue but upon probable cause. Get it in your mind. Under Gerstein versus Poe, 1975, a person subjected to a warrantless arrest must receive a prompt judicial determination of probable cause as a prerequisite to extended detention. Do you hear that? A person subjected to a warrantless arrest, that means you get pulled over in your car and they take in your car and they arrest you. That's a warrantless arrest, man. What they got going on? That you have to be committing a gross misdemeanor, which means harm. Y'all not reading what's going on? What they talking about? For you to go to jail, you must have brought harm. You don't go to jail for not harming anybody. That's not how this country works. That's not how this country works. And if you support that, you don't belong in this country, bro. Real talk. Like, we didn't have millions of our ancestors die for you to be coming over here and acting like you. Yo, I don't even know what to label that. It's wrong. We're just going to label it that. There is no need to label it any category other than wrong. There's a right and wrong with me. There is no categories of whatever thing you want to claim as a name, title of I support this party or that. It's either right or it's wrong. It lives in truth or it's in darkness. There is no either or. It is or it isn't. It's that simple. You either stand in truth by not harming another and then standing on those rights and never waiving them, or you succumb to the darkness. You waive your rights. You give in. You allow the slavery to happen. That's how it works. It's free will. Must receive a prompt judicial determination of probable cause as a prerequisite to extended detention. The magistrate judge as gatekeeper. The magistrate or judge as gatekeeper. What are we getting into now? So the magistrate or judge reviews the affidavit or sworn statements to assess whether the factual allegations meet the threshold of probable cause. Johnson versus United States in 1948 again, quote, the point of the Fourth Amendment is that inferences be drawn by a neutral and detached magistrate, not by the officer engaged in the often competitive enterprise of ferreting out crime. This requirement enforces constitutional primacy, ensuring law enforcement suspicions are subject to independent scrutiny. Possible outcomes: probable cause found inadequate. Again, getting dismissed or denied. Probable cause found sufficient, that the matter proceeds to formal charging via information or complaint or indictment, grand jury jurisdictions. Okay? Now, if the case is found inadequate, the dismissal or denial of charges or warrants. If the judicial officer determines the facts fail to establish a reasonable belief, and that's why we be having our disqualification already ready to go. I mean, not disqualification. Well, we do have that ready too, but our order of dismissal, right, ready for the judge to sign off on. Establish a reasonable belief of criminal wrongdoing. The request for an arrest or search warrant is denied. In cases where the defendant has already been arrested, particularly a warrantless arrest, of course, the judge may dismiss the complaint, leading to immediate release of the accused, absent any separate grounds for detention. Now, I saw someone in the chat talking about something earlier in relation to a person needing some help. And what I want you to know is that the Discord is in the description of this video. If someone can grab it, I can't grab it right now, and throw it in the chat. Or you can just go to the description, get in the Discord, and hey, man, we all work together. This is, again, y'all got to remember, this is we the people, okay? Now, the where are we at? Requesting was denied. In cases, immediately release. Exclusionary consequences. So, remember, we're talking about rules, doctrines, things we need to invoke, we need to establish, we need to know. If we don't know that, we're just going in to attack the charges that have been brought against us. We don't do that because we know we are creations of the Creator. And we know that no harm brought to another, there's nothing, you see what I'm saying? It has to stop. So under the exclusionary rule, because again, why? We have life, liberty, and the pursuit of happiness. We can go and operate in all of that. And if anything comes against that, hey man, you protected in all of your safe conduct. So under the exclusionary rule, Matt versus Ohio, 1961, evidence obtained from an unconstitutional search and seizure, clearly one lacking probable cause, clearly is typically subject to suppression. Thank you. Rendering it inadmissible at trial. Shout out to my boy Quentin. Shout out to my boy Quentin. What's up, Matthew? Y'all out there? Again, evidence obtained from an unconstitutional search or seizure, one lacking probable cause of an actual crime, is typically subject to suppression, rendering inadmissible at trial. We ain't even going to trial. What? Y'all ain't taking that. Y'all ain't finna rule in my favor? Disqualification. What? You want to argue with me? Injunctive stay, motion for relief, pending appeal. We not finna play with y'all. Get the judicial, man. We need to get a judicial review on these clowns down here trying to think they're going to violate my constitutional rights. Get y'all on some judicial review real quick. Brady complaints. Not to be rude, but again, we have to stand in honor. We have to make sure that everybody is keeping the code and doing right by the Creator. That's what we have to understand. Morality and integrity is at the forefront. Wong Sun versus United States, 371 in 1963, established the fruit of the poisonous tree doctrine, which I love so dearly, extending suppression to evidence derived from the intentional illegality. Illustrative example. Let's get into some hypotheticals again. A detective's affidavit states only, quote, confidential informant claims the suspect might be involved in drug sales. No further details. Let's do this a little bit different. Oh no, I'll leave it. Okay, so the judge concludes the affidavit lacks any corroboration or factual nexus. Where's a factual nexus that I have a driver's license in your system? Well, sir, we have a number here in our system. Okay, does that number show that there's ever been an application? No, sir. It's our tracking system to show that you've been suspended. You're suspended. Yes, sir. What am I suspended from? Well, it shows that your privilege is suspended. Your driving privileges are suspended, sir. Okay, good, sir. Is that my right to apply to that privilege? Is that what you're talking about right now, good sir? Sir, your license is suspended. My good sir, I did just have a question. If you don't mind just helping me out real quick, answer that question. You did just say that my privilege is suspended, correct? It's just my privilege only, though, right? Beyond that, nothing else, correct? you gotta get them, bro. You gotta get them. So let me see, dude. What y'all got going on in the chat, man? Okay. Grateful Dead still's in here. What's up? What's up, Lynn? I see you in this thing. Jamo, good evening. Ken, what's going on? Bill Thomas, what's going down? The Rose Girl, what's up, y'all? Kinetic, I see you in this thing. All right, let me get back to it, y'all. All right. Let's see, window. Nope, we're not doing a window. We're doing a whole screen just in case. Yeah. Oh, come on, man. Come on, man. Again, that factual nexus. The warrant is denied. Should law enforcement proceed without a valid warrant, any evidence seized may be excluded. Exclusionary rule, get it out of here. Policy and judicial integrity. A magistrate's refusal to authorize a search or arrest on insufficient grounds underscores the checks and balances function, preventing fishing expeditions or arbitrary detentions. Okay? If probable cause is found sufficient. Now, pathways to formal charging. Okay? Filing an information or complaint. In many jurisdictions, a prosecutor can proceed with formal charges once a judicial officer has confirmed the existence of probable cause. This is especially common in misdemeanor or lower level felony matters. The grand jury, of course, in federal systems and states that require grand jury involvement for felony charges, the prosecutor often presents evidence to a grand jury, even though they do it in a misconstrued way all the time. I'm not going to go into that right now, but if the jury returns a true bill, an indictment is filed. The seminal case, Gerstein versus Poe, again in 1975, the court held that a judicial determination of probable cause within 48 hours of an arrest is constitutionally required. Ensuring extended detention does not rest solely on police say-so. Thank you. We need to get some boundaries here. Key quote. A policeman's on-the-scene assessment of probable cause provides legal justification for arresting a person suspected of crime. But it is different from a judicial determination that probable cause exists for detention, preliminary hearing, and arraignment. Now, the post-determination, the defendant typically appears at a preliminary hearing, right? It's your preliminary hearing. We're showing up. We're getting there. We're figuring out what's going on. We're filing our things. We're ready to roll in states that use it, of course. Or arraignment, right, where I'm not pleading nothing. You ain't getting the plea up out of me, good sir. No jurisdiction here by special appearance pro persona. Not waiving any jurisdiction, thereby asking the court to move forward with a motion of strike of dismissal, where the charges are formally read and counsel is appointed if needed. No, we're not doing that, though. But if needed, I understand not all of us are able to go about it in this manner. The judge may also address bail bond conditions, of course, in the release, statutory factors, flight risk, danger to the community, practical consequences. A sufficient probable cause determination validates the arrest or search. The evidence secured is typically not subject to suppression on Fourth Amendment grounds unless a later challenge, Franks versus Delaware hearing, reveals misinterpretations. The case advances through the criminal justice process, discovery, pretrial motions, and potentially trial. Intersection with grand jury jurisdictions. Now, the Fifth Amendment right, federal, for capital or otherwise infamous crimes, the Fifth Amendment generally requires a grand jury indictment. Once magistrate, give me 1 second. Once a magistrate finds probable cause, the prosecutor can submit evidence to a grand jury, which decides whether to indict true bill or no true bill, or no bill, Grand jury as additional check. Even if a judge or magistrate is satisfied probable cause exists, the grand jury can refuse to indict if it deems the evidence insufficient. Alternatively, the grand jury might demand more extensive proof than the minimal threshold for probable cause. Historical and policy considerations. Now, the grand jury system evolved as a protective mechanism. Again, the grand jury system evolved as a protective mechanism. Got to protect us There's layers to all of our protections. We just got to be figuring every aspect out so that we can apply it. And wherever there are mistakes, that's where we cut the cord and eliminate ourselves completely out the whole thing, because then it's tainted. Ensuring citizens and jurors have a say in prosecutorial decisions. Costello versus the United States in 1956 held grand juries may act on hearsay or less formal evidence, but the end result still rests on whether the body believes there is probable cause. So the illustrative examples of probable ramifications. Case example A, probable cause denied. A local judge reviews an affidavit claiming the defendant looks suspicious near a crime scene without any supporting detail. The judge deems it inadequate for probable cause, denies the warrant, and no charges are filed. Impact. The suspect is not arrested or is released if already detained, and the police may have to gather more evidence to drop the investigation at this time. Case example B, probable cause approved. A magistrate finds sufficient facts that the defendant's specific actions and police cooperation link them to a narcotics operation, whatever the case may be. A warrant is issued, the defendant is arrested, and the case proceeds to grand jury. If the grand jury returns an indictment, the defendant is arraigned, learns formal charges, and the case moves toward trial or possible plea negotiations. Scholarly commentary and constitutional perspectives. Erwin Chemerinsky, Criminal Procedure, quote, the requirement that a neutral magistrate confirms probable cause, upheld by a robust standard, is indispensable to preventing erroneous deprivations of liberty and ensuring that arrests reflect the objective presence of wrongdoing rather than mere speculation. Again, pulling from Lawrence H. Tribe, American Constitutional Law. Procedural gateways, like the judge's probable cause finding the grand jury's indictment, guard against the raw power of the state's coercion. By placing the onus on the government to justify intrusions on individual liberty, the Constitution's architecture remains stable and fair. Keep it fair for all. Keep it fair for all, y'all. Policy justifications. So, requiring judicial approval of warrants. Requiring judicial approval of warrants and charges channels law enforcement zeal through constitutional filters, reinforcing the principle that freedom should not be curtailed absent a solid factual basis. You hear that? You hear that? Okay? Requiring judicial approval of warrants and charges channels law enforcement zeal through constitutional filters. Get them out. Reinforcing the principle that freedom should not be curtailed absent a solid factual basis. The public gains confidence in the justice system when arrests and charges pass independent scrutiny, reducing the risk of arbitrary and vindicative prosecutions. But that's not what be happening out here. And so again, that's why I come back to stating we have to heal the sickness. The sickness gets healed by us knowing the knowledge, by us enforcing when these violations occur. All it takes is us knowing who we are. Once you know who you are, the violations can't occur anymore like they want it to occur. It comes to a cease. Wait, what happened? Was I muted? Oh my gosh. I don't know what happened. I don't know if I was. I hope not. I hope everything's fine. Is everything working good? We got a good 5x. Mic working good? Oh man. I got problems over here, bro. Uh-oh, now I turned my thing green. Oh, now. Okay, sounds good. Okay, 5x5. All right, good. I had to wait, bro. I didn't know. Okay, so the public gains confidence in the justice system. Hey, if you knew you just coming in this bad boy, go ahead and give the channel a like real quick. We do a whole bunch of work in the background. The Discord link is down in the description. You can follow up with us. We do a whole bunch of work in the background together now. If you want to learn, this is part 2. The public gains confidence again when things are not in a vindicative aspect. So the concluding observations, binary nature of judicial ruling, the judge's or magistrate's probable cause determination often boils down to a binary outcome. Deny if insufficient or approve if sufficient, yet the repercussions are profound. And again, this is why we tie in all of our aspects of what we just went through earlier before this chapter. The immediate consequences, deny or dismiss, The defendant walks free, subject to further lawful investigation. Evidence seized may be suppressed, ending the case early. Approve and indict. The gears of the formal prosecution engage, leading to arraignment, possible bail decisions, and eventually trial or plea negotiations, of course. But we're fighting all the way, you dig? Upholding constitutional primacy. At this critical juncture, the Fourth Amendment guarantee that the state must have probable cause is rigorously enforced, preserving due process values. Okay? Due process is so key to everything we have just discussed tonight and is everything. Values integral to the criminal justice system. Key takeaway. The magistrate and judge determination of probable cause is the gatekeeper function of American criminal procedure. He is the gatekeeper of the state, and he is also, hopefully he's not a gatekeeper of my rights, but he is the gatekeeper of the pedestal of my constitutional, well, my natural rights, my unalienable rights, because they go well beyond just the Constitution. Okay? A finding of insufficiency halts a prosecution. You hear that? A finding of insufficiency when we invoke halts prosecution, at least temporarily, while a finding of sufficiency propels the case to formal charging or indictment. This mechanism upholds constitutional primacy by ensuring liberty is not curtailed without a clear factual foundation. And of course, all of the sources and sites that we went through again. Okay. Oh, look at what we're coming into on part 3, y'all. Look at what we're doing on part 3, y'all. We're getting into the advanced canons and maxims and statutory construction. And that first bad boy is going to be about the Whole Rule Act. Yeah, buddy. Good old Whole Rule Act. We're getting into it next, you dig? Going back to the beginning. I need you to take me back. Here, let me do something. Watch this, y'all. Y'all ain't gonna tread on me. Y'all got the last tread. We're done with it, man. Don't tread on me. Don't tread on me. Yeah, man. Don't tread on we. That's how that goes. Don't tread on me. We holding true to our ancestors. We're holding true to the spirit. We're holding true to what America is. We're holding true to what this nation is. This land is overshadowed with wings. For those who know, you know. We talking about Aqualius. Hey, man. The land overshadowed with wings. America. Erica. I appreciate y'all being with me tonight. I just wanted to finish this one off kind of crazy. If y'all want to hit up and chat or just move or do anything, we can go into the Discord. We chilling over there tomorrow morning, though. Just so you know, we're going to be having Rick Martin. Yes, Rick Martin. Oh! We're going to be having Rick Martin come through on Operation Wise, though. So last week we had Eddie Craig. Tomorrow we're going to have Rick Martin on the Operation Wise Dome. So for all of the people who don't know, the link for Operation Wise Dome is in the description. And the link for Operation Wise Dome is in the description. And we're going to have Rick Martin on tomorrow. So, no, not Ricky Martin. We're talking about Rick Martin, the old right to travel guy down in Texas, got arrested and got a big old check, got his car paid for, and, old Rick Martin. Tomorrow morning, we're going to have, and he's going to be on Operation Wise Dome with us, so that's going to be pretty good. And what else we got going on? Look, if you haven't signed that traffic law reform petition that's in the description of this video, I would really appreciate it if you do so. We got to get this bad boy to 1,000. Once we get it to 1,000, then we can start sending it off to all the legislators. We can start sending it off to all of our senators and representatives. Like, we're getting serious about it because we're going to start getting sponsors behind that, bro. That's going to get a lot of push because we already got the crack in the concrete, which again is Nevada. So if we just keep pushing forward, again, if y'all want to get in contact with me, if y'all want to get in contact with the crew, the squad, we've all are working in the Discord. You'll see all kinds of stuff going on in the Discord. This is we the people, okay? This isn't Cameron. This is we the people. Because all power is inherent, not in me, not in just you. It's we the people. We just have to get back to bringing morality and God at the forefront, understanding that we are all part of the great creation and bringing that to the forefront again, y'all. We have to bring that to the forefront. If we bring that to the forefront, this nation's going to change. You can already see it changing right now. It's already changing, okay? No more treading on us, y'all. Don't tread. Wait, let me flip it around so it's spelled right. Don't tread on we, the people. Get the mic out of the way, okay? Don't tread on we, the people. I love you. I'll see y'all tomorrow morning with Rick Martin. I'll be in the Discord.